ladies and gentlemen, esteemed participants, and honored guests. Good evening. It is with great pleasure and enthusiasm that I introduce our highly anticipated CMC mediation training program. In a world filled with complexities and conflicts, the art of mediation has emerged as a powerful tool for resolving disputes, fostering understanding, and promoting harmony. As we embark on this journey, we recognize the significance of mediation and its potential to transform lives and communities alike. The primary objective of this mediation training program is to equip individuals with the skills, knowledge, and mindset required to become proficient mediators. Whether you come from legal backgrounds, social work, corporate settings, or any other walk of life, mediation is a universally applicable skill that can enhance your ability to navigate conflicts effectively. By the end of the program, you will not only comprehend the theory behind mediation, but also gain hands on experience through role plays and case simulations. Our team of expert trainers and experienced mediators will guide you through the process, imparting their wisdom and insights garnered from years of practice in the field. In addition to the personal development that you'll undergo, this program also opens up new opportunities for you to contribute to society. As mediators, you will be empowered to play a vital role in resolving disputes within families, communities, workplaces, and beyond, fostering collaboration and long lasting solutions. I take this time to thank Ms. Tanu Mehta, who is the chairperson of the Mediation Committee at the Bombay Chambers and the guiding force for this program. She's an advocate in the High Court with over 27 years of experience and a senior mediator with CMC. Ms. Mehta, through her various efforts, has aspired to create a community of trained mediators who will work together, share experiences and knowledge, and has continuously raised the bar for mediation practices. She believes in the power of mediation to build bridges across industries, empowering persons from every stream of life to make our world a more compassionate and harmonious place. I now have the immense pleasure to introduce to you our trainers for this program. Ms. Ganda Sahu is a conflict resolution professional. She's a lawyer who facilitates conflict resolution through mediation and dialogue. She also serves in the social sector in the field of conflict resolution, mental health, and gender justice. Ms. Ganda runs the Women's Legal Aid Cell at the SHB Foundation and serves on the board of Connecting Trust, an NGO dedicated to the cause of suicide prevention. She's an empaneled mediator at the Bombay High Court and a resource person for the Pune District Legal Services. Ms. Ganda is invited as an expert visiting faculty to engage classes on mediation at prestigious institutes including ILS Law College, Pune, Maharashtra National Law University, Mumbai, and Praveen Gandhi College of Law, Mumbai. Our next trainer on board is Dr. Lalit Kapoor. Dr. Kapoor is a general and gastrointestinal surgeon. He's a founder member of the Association of Medical Consultants, Mumbai. The association consists of over 13,000 medical consultants and is the largest body of its kind since its establishment in 1972. He also founded the first medico-legal cell in the country over 40 years ago. He has had the honor of being invited by the National Judicial Academy 4 times to participate in workshops for district and high court judges. He has assisted hundreds of colleagues in dealing with their medical legal problems. He has also worked in crafting a unique professional indemnity scheme for doctors. He is the president of the Federation of Associations of Medical Consultants of India. Apart from that, he serves as the medical director at the Shakuntala Memorial Hospital, Mumbai. Additionally, Dr. Kapoor has also authored the book Better Safe Than Sorry: Medico-Legal Do's and Don'ts. Before I take my leave, I urge each one of you to embrace this learning experience with an open mind and a compassionate heart. Together, let us strive to make a positive impact one mediation at a time. Thank you for joining us on this exciting journey. Your commitment to this mediation training program is a testament to your dedication to resolving conflicts and building a better world. Let us begin this transformative adventure together. Thank you. I now cede the floor to Ms. Ganda and Dr. Kapoor.
Thank you, Mrinalini, for your kind words and for setting the stage for us. And welcome to all the participants. We'd like to begin Dr. Kapoor and I with, just getting to know you all. If you could introduce yourselves, your name, and where you are joining from, and perhaps a line or two about yourself. It would be nice. So we will be interacting a lot. So this program is not something that is going to be a monologue. It's going to be a lot of interactions. So let's start doing it from the first minute of the program. So may I invite you to introduce yourselves? Can we start with Miss Sonu Balsara? Dr. Sonu Balsara, is it?
Yeah, I'm Dr. Sunnu Balsara. I'm from Mumbai. I work as a consultant anesthesiologist, and I have also done my diploma in medical legal studies a year back from Symbiosis. And somehow I found it quite interesting, and unfortunately, I couldn't do much with just the diploma. And I thought this would be something where I could, move forward.
Yes, that's really nice. In fact, we are looking at working in this field. This field needs to be worked into as far as dispute resolution is concerned, and people like you can contribute a lot in that way. Thank you, Ms. Balsara. Dr. Balsara, sorry. Rushali?
Hi, good evening, everyone. My name is Rishali Patkar. I have been working with an insurance industry for more than 25 years. Just recently, I've moved out of insurance industry, starting with my own legal practice as an advocate. I'm currently pursuing my master's in mediation, and since seriously want to get into this, thought of certification, acquiring a proper certification into it, and that's how I'm here.
Thank you, Vrushali. Also, we have some professionals here who are not directly related to the medical field. So please understand that we will have additional sessions for the medical field. The program itself is a mediation training program as required by the Supreme Court. So that's the structure of the program, and that's common to all professionals, lawyers, everyone. But we will be having additional sessions to address concerns or issues that are specific to the medical profession. So that's an additional area that we are covering here. Mr. Praveen, CA Praveen Navandar.
Good evening. I am a chartered accountant, having my individual practice for 32 years. Then now, since last 7 years, I am practicing as a resolution professional for all the SIG companies. And I am also practicing as a registered valuer for financial assets. This insolvency and bankruptcy is a new one for last 7 years. You must have read. If you read any the business paper, you will get a lot of news about the same, like Jet Airways or Go First or Bhushan Steel or SR Steel and such type of cases. I am handling one large case of Videocon Oil last 3.5 years. It is said now that in insolvency field also a lot of mediation will be involved.
Yes.
That attracted me. I was not very much knowing that this will be more focused towards the medical profession. But anyhow, things are almost same. I will pick up whatever best I can. Thank you very much.
Thank you. And welcome. Dr. Sirur.
Hi, I'm a practicing dermatologist. In addition to this, I'm in two other fields. One is in law. I'm a medical legal consultant, done my LLB and LLM, and I've been in that area also for the last 27 years. I've been representing doctors, hospitals, and nursing homes before the consumer fora. Now I do more of risk management, more of chamber practice rather than appearing in courts because it takes a long time to be in the courts. I have also worked and I'm working in the insurance space also. I'm a fellow of the Insurance Institute of India. I've been a chief administrative officer of a third-party administrator, Paramount Health Services, and I give opinions to insurance companies on the claims and on the legal aspects, the insurance aspects, as well as the medical aspects. I have also done this mediation for a lot of medical legal cases. And as I have discussed with you and others, the purpose is probably to have a certification so that, it's more easier, like you may have the experience, but if you don't have the certification as mandated by the Supreme Court, probably it doesn't work. So I'm here for that.
Thank you,
Thanks.
Dr. Sirur, and thank you for joining us. And also, I think we will have a lot of interaction with you and we will learn from you and your experience. So that's going to bring in a lot more value to the program. So thank you for joining us. Ms. Preeti Jaikar.
Hi, good evening, everyone. I'm Dr. Jaikar. I'm from Bombay. I'm a consultant general surgeon here. And I am very interested in this topic of mediation. And I think I was looking forward to it from the first time that you announced it. I think it's something that may help in a lot of cases that we are seeing. I'm also doing a little bit of medical legal consultancy also. Not full time, but part time. And definitely looking forward to learning more about this.
Thank you. And again, we are all going to learn from each other. All of you come from experience and we will learn something from you, and hopefully we will be able to give you some information about mediation. Mr. Sudhir Tarote. I'm going to call you Mr. for now because that's what's appearing in your name. So I'm noting down what are your address, how to address you. Yes, Mr. Sudhir Tarote.
Yes, good evening all. I am Sudhir Tarote. I have been already part of a mediation training program. Thank you so much for giving all of us, those who were already a participant of this program, for allowing us to be part of this refresher training program. I'm an assistant professor. I'm in academics from last 13 years. Right now, I am working in Shankarao Chauhan Law College, Pune. I have completed my PhD in ADR, specifically in international commercial arbitration. Thank you.
Thank you, Mr. Sudhir, to join us again. And yeah, it's wonderful to see you all again. Miss Ketki Ward.
Hello.
Hello.
I'm Dr. Ketki Ward. I'm a practicing physician and gynecologist last 15 years, and I'm working in full corporation veterinary home as a gynecologist, and I have clinical and administrative responsibilities too. I'm looking at this as a way forward to learn, and I hope to learn from you guys.
Welcome. And we also will learn things from you. So it's going to be wonderful. Leena.
Good evening all. I myself is Advocate Leena Hopte, practicing in Thane, Bandra Family Court, and in Mumbai. Having 25 years practice more in civil side and family side, and now court annexed mediator in Thane District Court. This is my short intro, and thank you, ma'am, for giving us this opportunity to join this program.
Thank you. Thank you, Leena. Welcome. Vishwanath.
Am I audible?
Yes, Vishwanath.
Yeah. Good evening to everyone. This is Vishwanath. So I am a shipping professional. I have done my BE Mechanical and MBA. Now working for a shipping field from past 27 years. So I'm working for a public sector company, Shipping Corporation of India Limited. So I am here because many times I have attended arbitration cases to my company. So I am here to learn further. So I have already attended the full course. And thank you for inviting me for a refresher again. Thank you very much.
Thank you, Vishwanath, and welcome. Kamakshi?
Hi, good evening, everyone. So I'm Kamakshi. I'm a lawyer and a psychologist by profession. And yeah, so conflict resolution as a concept is something of great interest to me, and it's something that I study constantly. So that's the reason why I'm here.
Thank you and welcome. And Ranjan, Advocate Ranjan, welcome. Can you introduce yourself? So, short introduction.
I'm an advocate practicing for almost more than 35 years and have a background of being a company secretary fellow member. Did my arbitration diploma with the Institute of Company Secretaries of India and trained by the Chamber of Commerce, Bombay Chamber of Commerce as a mediator. And also I am holding a certificate from the University of Bombay for ADR that I did in the year 2005, from March 2005 to August 2005. Had an opportunity during my stint as a company secretary to attend some arbitrations related to the ship scrapping. And in my personal practice, I had been arbitrator in couple of matters. Had an opportunity to do some mediations in the court of law. And I really feel elated to be back for the refresher course. Thank you.
Thank you. Thank you for joining, Ranjanji. And we shall now proceed with the session. And I will invite Dr. Kapoor to introduce the course, also help us to understand the challenges faced by the healthcare industry because of conflicts, of various types of conflicts. And over to you, Dr. Kapoor.
So good afternoon, delegates. It's indeed a pleasure and an honor to be addressing such experienced people. In fact, we might need to know, we may not know who needs to learn from whom. So but as Ganda said, we all need to learn from each other, and which is what we hope to do. It's a very vital subject, gaining more and more importance as the time goes by, particularly as far as I will be focusing more on the medical sector, healthcare sector, because that is where for the last 4 decades, I have been able to get an insight into the type of problems that occur between patients and doctors. And of course, there is a rapid rise in litigation between patients and doctors. Patients are now consumers after the Consumer Protection Act. Patients are now consumers or grahak or clients, which never was happened earlier. and doctors are no longer doctors, but they are called HCP, that is the healthcare providers, much like any service provider, internet service provider, and so on. So that is the change in scenario which has happened, and all the more reason why mediation assumes a very, very important role, which of course it is there all over the world. So I'll make a small presentation. Ganda, can I share the screen? Can you allow me to share screen? I have a PPT and we'll go through. You have to
Mrinal,
Yes.
will you give him host rights, please?
Yeah, I am not the host, so I can't give Dr. Kapoor the access, but
Yeah, just a minute.
yeah, I can perhaps share the presentation if Dr. Kapoor, if you could send it, I think we can share the screen through our device.
Just a moment. No, it is a host disabled participant.
Yes, sir. So I am the co-host, so I can't. Just give me 1 second, please. I'll get. Sorry. So in a minute or two, I think you'll be getting the access to share the screen. So yeah, we're really sorry for the delay, just like a minute or two setback.
We are waiting for that.
Yeah. So I think you're the co-host now, so you can share the screen.
Can you see the screen?
Yes, sir.
All right. Okay. What is moving?
So make it full screen, sir, please.
Yeah, just a minute. Right sharing. Yeah. What he's saying. All right. Can you see?
Yes, sir.
Yeah. Okay.
Yes.
All right. This I will skip. Already you have been introduced. This can go. Okay. This is the book I have written on medical legal do's and don'ts. It's called Better Safe Than Sorry. So it's the topic is quite self-explanatory. The title. Yeah. Okay. So I give a little perspective of mediation or dispute resolution, more particularly in medical legal cases. The latest buzzword in legal circles all over the world, even in India, is alternate dispute resolution. A statement from an American legal expert sums it all. The courts of this country should not be the places where resolution of disputes begins. They should be places where the disputes end after alternative methods of resolving disputes have been considered and tried. Just a moment. Right. This can go up. Okay. So this is what it says, that disputes should end in courts, not begin in the courts. The vast majority of medical malpractice cases are resolved outside of the court. This is, I am talking of USA. Just a moment, please. Can we pick it up? Right. Okay, very good. The vast majority of medical malpractice cases in the USA are resolved outside of the court. Few of these types of lawsuits go to trial. According to a study conducted by the US Bureau of Justice Statistics, only 7% of medical malpractice lawsuits are decided by a jury. This means that an estimated 93% of malpractice cases are resolved outside of court before trials occur. Now, an average out-of-court settlement is $425,000 US, whereas the average court award is $1 million. Hence, it's a lot cheaper to settle. Now, it's important. I would make references to the USA scene. USA is the litigation capital of the world, and we somehow are following that pattern as far as medical malpractice is concerned, and we need to really have a kind of a perspective. Now, what is outside court settlement? An agreement between the parties that resolve the dispute without the court's involvement and ends further proceedings in the case. That essentially is it. The figures of alternate dispute redressal in medical legal cases in India are reverse of USA, which means only 7% cases might be resolved outside court, whereas 93% go to court. It's exact reverse of USA. Now, really, what is the reason? The reason is that insurance companies in our country, now you must know that most doctors, at least the sensible ones, they have what is called the professional indemnity insurance, which covers them for liability, medical legal liability, including legal costs and compensations if and when awarded. So in our country, insurance companies are not really even aware or much interested in out-of-court settlement, and would rather have a court decide the compensation. And the reason is clear. Now, because we have been handling these kind of situations where patients go to court, and both the parties are willing and anxious to settle the case by mediation. But because the doctor is insured, he has this professional indemnity insurance, which now is doctors have been advised to take sum assured for 1 crore, 2 crore, 3 crore, because the compensations are now being awarded in even astronomical figures. The largest compensation, record compensation, was 11 crore rupees in the Kunal Sahu case, where the lady was a US resident. And therefore, insurance companies, the parties are anxious to settle, to mediate. But because insurance companies do not really have a provision, they do have a provision, but it's very rare that they would like to settle a case out of court. They would rather have the court give an award. And partly the reason, I believe, is that in India, the judicial system is so tortuous that even the under the Consumer Protection Act, which was to begin with said would settle a case in 90 days. Now that has not happened. It is no longer a speedy redressal mechanism. It may take not 90 days, but 90 months. There are cases where cases have gone on for 15 years, 20 years, more so if they go under appeal. And therefore, insurance companies feel that, look here, let the award come, let the compensation come, we'll see at that time, and we don't want to settle now. Now, that is what which means that unless the doctor wants to compensate the victim or the claimant from his own pocket, he would be reluctant, and he would also rather have the case continue till the court gives an award. And so that is the reason. Whereas in the USA, the ADR or settling out of court or mediation is part of the function of the insurance company. And that is the reason why 93% cases get settled out of court or by mediation, so that the cases do not prolong. It's good for the doctor, good for the patient. Now, our association, the Association of Medical Consultants, we have over 13,000 consultant doctors, that means the specialists of various branches, as well as nearly 1,000 nursing home establishments and diagnostic centers. So they are part of this association. And we have a special professional indemnity scheme, which we have crafted. It's a tailor-made policy, and which we probably have the largest membership of this indemnity scheme. We have over nearly 7,000 doctors who are part of this scheme, which is a group insurance scheme. Now, how do we handle this? So what we have done is, though the insurance companies are reluctant to mediate, going for mediation and settle the dispute, we have an MOU with the insurance company, where we have clarified that this option will be exercised whenever we feel. So the way we work is, we have a panel of 2 senior doctors of the concerned specialty. Suppose it's a case concerning a cardiologist, then we would have 2 senior cardiologists who and the medical legal cell members and a panel advocate. We have a panel of advocates to do an in-depth study of the case, to study the various facets of the case and give a kind of an expert opinion. Now, a decision for or against an alternate dispute redressal is reached on the basis of this kind of analysis, which I will explain to you as to what are the areas we would look at. Now, what we need to understand is that when we say negligence, there are several types of negligence. And I will not go into that. But the types of negligence which we would look into while going into a mediation. Now, we have classified negligence into a real negligence, damage following occurrence of known complications of a procedure or an operation. Thirdly, a perceived or imagined negligence. And lastly, a non-existent, namely mischievous, where there are several synonyms: mischievous, motivated, fabricated, also called vexatious litigation. Now, these are not unknown. So these are the categories really. So we first have to decide under which category this allegation of negligence is being made, because we have any number of examples in each of the categories. Now, as far as the association is concerned, ADR is recommended or attempted, because there's no guarantee that your mediation will succeed. It may succeed, it may not succeed. One of the parties may not agree to it. So it is attempted only in real cases of negligence or in cases of complications following negligence. Now, negligence, what is the definition of negligence? Negligence is defined as deviation from the standard of care which results in damage to a patient. That is how negligence is defined. And quite often we find cases which we categorize as indefensible. The deviation from standard of care is indefensible, and we advise a mediation or an alternate dispute redressal mechanism. Now, I'll very quickly tell you what we mean by these terminologies. Now, real negligence, put simply, these are cases, the real negligence, in which a majority of doctors, including your own colleagues, when told of the facts of the case, would readily conclude that definitely the conduct of the doctor constituted negligence, as a result of which the patient suffered avoidable damage. So you come to the conclusion, yes, there was negligence, because when we say standard of care, it means it is what a reasonably competent doctor would have done or not done, conduct which he would not have done by a reasonably competent doctor. So if we come to the conclusion that a reasonably competent doctor would not have adopted this procedure or would have omitted to do certain things, then we would call it a real negligence. And undoubtedly, this case needs to be settled and not allowed to go to court. This we would call it an indefensible case. And there is a reason. The reason why it's not good for anybody, neither the plaintiff nor the defendant, for it to go to court. And one of the reasons is, of course, it would take years and years and years. So it would be unproductive. And secondly, by how we justify to the doctor that it is also not only bad for the individual doctor, it is also bad for the entire medical profession. Because what you're doing is, you are creating a precedent, you're creating a case law, or what they call the judge-made law, where that will be quoted. So if you know that this case doesn't stand on merit, there's no point in pursuing the medical route of the litigation route, and therefore there's no question that it has to undergo mediation. Now, as I said, this category would fall under the doctrine of res ipsa locator and fit to be considered indefensible. Some examples: retained foreign body. Suppose I operate, I leave a mop inside, I leave a towel inside, I leave an instrument inside, operating on the wrong side or the wrong patient, which is patently indefensible, wrong medication, wrong dosage, and gross deviation from this standard of care. So these are indefensible cases. But who decides? So as I said, we have this mechanism where we have experts from the same specialty. We have advocate, one of our panel advocates, and of course the medical legal cell who has been dealing with these issues. So that is the first issue to be discussed. If we come to the conclusion that this is a real negligence, then we can initiate a discussion, a dialogue, and that is where now that is our weak area, and that is where I think Ganda is so passionate about this, doing a fantastic job, and to create people who would do it professionally. We are the people we put together can't do as good a job as Ganda or the other trained mediators would do. So this is a win-win situation. Mediated solution is a win-win situation for all concerned. It's a win-win for the patient, of course, for the doctor, for the hospital, for the insurance companies. Now we convince them that, look here, court might award 30 lakhs, 40 lakhs, eventually. Whereas if you were to mediate, possibly you could do it, as I showed the American figures, the mediated settlement is far less than what the court might award. And it is good for the judicial system as well, because it cuts down the load, cuts down the pendency in our courts, which is a huge figure, as you all know. Now, what is the downside of settling? This is our perspective. Our perspective meaning the medical professionals' perspective. So what is the downside? that downside is if frequently this is done, for every complaint that comes, you say, all right, let's mediate, all right, we'll settle and all that. What it can do, it can provoke more disgruntled patients to try and knock out money out of some unfortunate, inevitable situations. And this could have a snowballing effect, because the word goes around that, look here, you say I'm filing a case, I'm doing this, and then the doctor says, okay, let me settle. So that is the downside. Too many of these cases, if handled by the insurance companies, now which is as it should be, as I said, in the USA, it would be insurance company would be a party in the mediation, and because the doctor has insured for the liability, would bear the cost of the compensation. Now, if there are too many of these cases which the insurance companies handle, which we of course have made them do it because of our MOU with them, and we have convinced them that this is the right way to go about it, it's good for everybody, then what would happen is, would most certainly lead to considerable upward revision of the insurance premium. Now, when I started my practice, my insurance premium was, you will not imagine, was 150 rupees for a few lakh of rupees. And today it is 50,000 rupees. So the premium, after all, the insurance companies are not doing charity. So they have to see their balance sheet. And if more and more compensations are given, the premium are going to increase. And at the end of the day, this is going to be passed on to the consumer. And so too many of these, that could be the effect, which is actually happened in the USA. In USA, because a lot of cases are settled by the insurance company, the premium are pretty high, almost 15% of your annual income of the doctor. And at a point of time, a doctor is forced to retire because he cannot afford to pay that premium. Probably he is not earning that much to be able to pay the premium. So that is one, we have to keep it in mind. And therefore, and being an easier way out, it might prompt more dependent doctors to resort to this. Who wants to go through all this long drawn litigation? And injudicious, unindicated out-of-court settlements are harmful from all angles and should not be resorted to. So there should be merit in doing this settlement. Hence, this should be considered judiciously. Now, as I already mentioned, that the Consumer Protection Act said we'll finish the case in 90 days, but it may take 90 months. And it said it is a speedy redressal and an inexpensive redressal. But the fact is something else, that the litigants spend lakhs of rupees because advocates don't charge small amounts. The legal fees are pretty high, and they spend lakhs of rupees and spend a lot of time undergoing this case. And therefore, the question is that we need to look at alternatives. Now, there is in the Consumer Protection Act 2019, as you are aware, the earlier Act 86 Act was replaced, not amended, but a new act was passed, 2019 CPA. Now, under this act, there is a provision for mediation cells to be attached to every forum, which is a very good thing. Every forum, let it be the district forum, state forum, there will be a mediation cell attached to it. And of course, they would probably have their official mediators attached to this cell. I don't know how they would work. But the surprising thing is, if you go through the rules, medical negligence cases are excluded from mediation. Of course, I'll qualify this. They have not excluded all medical cases, but they have excluded those medical cases where negligence has resulted in death of the patient or grievous hurt. In those cases, they say mediation is excluded. Now, this is something very strange. This is not pro-consumer. The Consumer Protection Act is supposed to be pro-consumer. This is anti-consumer, in fact. If at all, mediation has a big role, it is in medical negligence cases, more than in any other case, because the victim needs relief here and now, and not after 15 years. And this is something which is strange, and which our association has been trying to discuss with the Consumer Affairs Ministry and tell them to remove this exclusion. However, I am told even Tanu Mehta, I think, had shared one post which said that there is a new Mediation Act. I think Gandha will know about it, which has been passed recently, the Mediation Act, which permits this. And so perhaps this might not be a problem as far as mediation in the medical sector is concerned. Yeah. Now, there are certain special features in medical cases, which I had shared with Gandha, which we need to ponder upon and try to find out a type of alternate or how to go about it. Features which would differ from other disputes, like the industrial disputes or business disputes. There would be some difference, which we need to factor in while talking about mediation in the healthcare sector. Now, here what happens is, imagine a patient undergoes a major surgery and one known complication occurs. After all, this is something which could happen for several reasons, because as we've said, medicine is an inexact science, and therefore things do happen unexplainably, and rare complications can occur. So, but in a case like this, suppose a patient undergone a major procedure or a major surgery, unfortunately has a major complication. Now here, nobody is going to talk of mediation or at that point of time. They are more interested in now further treatment of the patient, and there the demand is for instant compensation. Now there are cases I know quite recently, after a hysterectomy, patient developed a complication, and the relatives all pressurized the doctor, said that nothing doing, we are shifting. I mean, since you are asking us to shift to a higher tertiary hospital, you have to pay the entire bill of this treatment. You know, we are not going to pay. Now that becomes like a instant compensation, failing which in occasional cases there are threats of media, print, electronic, social defamation, and there are even cases, political goons filing criminal case, mob violence, and so on and so you often read in the newspapers, right? So here the question is of urgency. So Gandha, you understand what I mean? That here there is a question of urgency. We don't have time to have several sessions of, you know, so what do you do? What does one do? So that is one aspect that needs to be factored in. The doctor and the hospital are overwhelmed, and therefore, as I said, what kind of mediation can be done in this scenario? Because mediation is not some quick fix solution. It needs to meet, understand, etc. Now, we recently had a case where a patient was operated and there were problems. Patient needed prolonged hospitalization, which would have meant a lot of medical expenses. The patients are requested to shift to a public hospital so that the cost factor could be controlled, and which they said, nothing doing, we will not shift there. So these are certain things because of the type of situation which could lead to a conflict. Now, this is again, really speaking, whenever a patient undergoes surgery or any major procedure or any procedure, as per the judgment of the Supreme Court, Prabha Manchanda judgment, the informed consent assumes a very important role, because every procedure, every surgery carries some risk. There's nothing, no one without risk. And informed consent, the aim is to, as I said, see, earlier we had the doctor-patient relationship was a paternalistic relationship, which means the doctor was like a parent, like a father, and why would he say anything wrong? But over the years, it has changed into autonomy, patient autonomy. So patient has to be explained that, look here, this is the procedure that is being done. These are the benefits. These are the procedure alternates available. These are the risks and consequences. And after having understood, the patient says, I give my informed consent, that which means consent is consent also for any possible mishaps. But when a known risk of a particular procedure occurs, as far as the relatives are concerned, I mean, naturally, they are not wrong. They would say there must have been some negligence. But for a doctor to have to compensate for every injury would mean that the doctor is made to assume the role of an insurer. The doctor is only a caregiver or trying to cure the patient. He can't give a guarantee or a warranty. So it says, no, some damage occurred or some complication occurred, known, unknown, rare, it doesn't matter. You have to compensate. So that is one thing again, which has to be in some way factored and understood. And I believe as the lot of reforms are required as far as our sensitization of our insurance companies, because it's a risk which they are covering, and the patient deserves to be compensated. There's no question about it. He has to be compensated. Question is how exactly this ought to be done. Now, the way we have been handling is no sooner a complication occurs or some kind of injury occurs, which is there's a possibility of a litigation. An immediate post-complication counseling is done to the doctor, assistance. Now, as you know, the allegations against the doctor can not only under the torts law, that is the civil law, also under criminal law. Also, they can go to the, of course, Consumer Protection Act, which would come under the civil law, or to the medical council for disciplinary action. So various fora are available to patients to do that. And quite often police complaint is made, a criminal case is filed, even in a medical injury, where it is treated like any criminal offense. And so assistance in case of police complaints, pre-litigation advice, dealing with a legal notice, review by experts of concerned specialty, legal opinion. And then, as I said, we have divided the types of negligence: decision on alternate dispute reducial or pursuit of the litigation process. And we have the own protocol with the insurance company, which we have more or less, probably our insurance professional indemnity has done maximum cases which have been settled before being allowed to go to the court because of our arrangement with the insurance company. So the other issue, which again, as I had mentioned earlier, which we will need to have to factor in, is the insurance company. What most of the time our attempt is, the case should not go to court at all. It should not reach the court and it should be settled. Now, this is, as far as the insurance company is concerned, they have a problem with that. They say this is not, our insurance company provides for out-of-court settlement. And they say this is not out-of-court settlement, technically. because it did not go to court. The matter never went to court. So we said, never mind, it didn't go to court. We are calling it pre-litigation settlement, even before it goes to court. We settle it much before that. But the question is that how do we make this agreement with the complainant judicially foolproof? How much is the judicial value of this MOU? Of course, we have an MOU where this settlement terms, what you call it, consent terms are done. But because there is no case in the court, we cannot get the approval of the court. So that is one issue which we need advice and help from all the learned people here as to how to do it. And of course, the consumer courts, they do have a pro-consumer bias, which is, yes, as it should be. And quantum of compensations is something which, as in the USA, there need to be some capping of compensations, because that is otherwise going to spin out of control, and it is ultimately also going to harm the person who is receiving the treatment. So therefore, we need to get in sync with what is happening in other countries. In New Zealand, Netherlands, for example, they have the no fault liability. The no fault liability, where you don't have to prove. Here in this country or even in USA, unless you prove the person negligent, there is no question of comp. So first you have to prove the negligence. The patient may have suffered. Whereas the no fault liability insurance would mean, irrespective of whether or not there was negligence, there was damage, and that damage should be compensated. So that kind of mechanism we have to work on, and of course the ADR process facilitation. So because of all these high compensations, the people who support high compensations, proponents of high compensations like 2 crores, 3 crores, I told you 11 crores was awarded in one case, 50 lakhs. I know doctors who have had to sell their property to pay that compensation and so on, you know. So, but something good has also happened. The proponents say that because of high compensation, doctors will become more diligent and more careful, and patients benefit to that extent. So as a result, there is now, we see that in our situation on the ground, there is awareness of enhanced patient safety measures, error minimization, checklist, improved record keeping and patient documentation, the recognition of the role of communication skills, greater efforts to update the knowledge and skills, better understanding by doctors of their legal and ethical obligations and of the legal system. This has happened because of the fear of these high compensations. And of course, we have been promoting the concept of patient autonomy and beneficence, which is acting in the best interest of the patient. There's a great change after the Samira Kohli judgment of the Supreme Court in the understanding of informed consent, more introspection by discussion and debates by healthcare professionals, quality assurance and accountability, which are the new buzzwords. And therefore, this is what the role our association has been playing. Briefly, I have not gone into many other things, and of course, we'll be happy to have any queries so that we can have a better understanding of the subject. Thank you.
What is your association known as AMC?
Our association is 51-year-old association. 51 years. We celebrated Golden Jubilee. This is called Association of Medical Consultants. These are all specialists of the only association in the country which has specialists of all shades, whether it's a cardiologist, dermatologist, surgeon, gynecologist, under one umbrella. and we promote ethical practice and also create awareness as far as litigation is concerned.
And they are, doctors all over India are members there.
Right now, we have branches in Maharashtra and Karnataka, and we are in the process. It's not really a pan-India, but we do have branches, several cities in Maharashtra and in Karnataka.
Thank you,
So
Dr.
this case laws which you have referred, that copy
Yes.
will be circulated among the participants, or how it will be?
Which case laws are?
This you said na 111 crore case or one autonomy of this, or
I can share it with judgment, or even if you go on the net, if you say Kunal Saha, even if you just type Kunal Saha, there's a lot of this analysis, discussion is on the judgment, because it was the record compensation awarded in Indian history.
the better is if you share it to the chamber and
Yes.
chamber shares us to the.
We can do that.
We'll get that. We'll arrange those copies of the judgments. We will arrange. Thank you, Dr. Kapoor, for that insight. I think the questions you have raised are the questions that would be in the minds of the participants who have, who are looking at mediation in the healthcare sector. These are absolutely the kind of questions they will have. And thank you for giving us a background in terms of how the cases have been handled so far. And, giving us hope that mediation can be used, and it is already being used, and perhaps with a more structured process we can have better systems being developed and processes being developed that can be used where conflicts can be handled better. Because this is a mediation course, I'm going to park Dr. Kapoor's questions for a while, get into mediation, and I feel that a lot of these questions will be answered during the process. All of you would be able to understand how the process works, what are we doing in this whole system. And then we will have another session which will answer some of these queries, which will be a session on the laws. But I feel also a lot of them will get resolved along the way. So that's what we will do right now. In case anybody has any other question for Dr. Kapoor, he can take that before we proceed with the other, with the mediation. We'll start with the mediation course.
I would like to ask a question. In good old days, because I'm 67 years old, so naturally I can say that good old days. Especially during my childhood and young days, what used to be, there used to be a family doctor, and he used to have a complete history, not only of the patient but the entire family. By any chance, this is just want to understand that the present day doctors or hospitals, whether they take the history of the patients, because treatment is what is right now before them, but whether that history is taken into consideration for the purpose of administering the treatment, a particular course of the treatment. Because many times it is just applying some sort of a balm in order to, okay, the patient may feel better now. So because this is one of the reasons perhaps that more number of disputes are arising between the medical practitioners and the patients. Thank you.
Medicine has made unbelievable, tremendous strides, and today You have spare part surgery, your knee is replaced, your lung is replaced, your heart is replaced. The amount of progress which is made is unbelievable. It's almost like science fiction. And the uterus is transplant somebody else's uterus, and the lady conceives and so on. And because of this high tech, medicine has become high tech. And there has to be, yes, you are quite right. Sadly, the family physician who used to form the basis of medical care is now extinct. You hardly ever get, if no doctor wants to just do MBBS and do family practice. Everybody wants to become a specialist, super specialist. Nobody wants to do the general practice. And so that is sadly, it has definitely affected the interpersonal relationship. It has become impersonal relationship. In fact, as I said, the doctor is now called a service provider, and now not only that, doctors are relying more on high-tech investigations rather than on clinical examination. History, of course, has to be taken. Without that, you can't decide which investigations you need to do. Uh, uh, but as you are aware, now the big threat is about the artificial intelligence. They are talking soon the doctor himself may become extinct. The stethoscope was thrown away long ago. It has only become a symbol of a doctor. Nobody uses the stethoscope. And a big battery of tests is done. And so that, of course, has happened. But that is a price you are paying. Today, you can imagine people are living much longer. People are able to overcome so many disabilities. Uh, the lung transplant and so on and so forth, which was unimaginable at one time. So that is a price you are paying for the technology and the progress. And doctors are depending more on technology, which is good and bad as well, because the human error becomes less as far as if you depend on this. And that is there. But as far as the disputes are concerned, they are again something which is expected. What do you expect if what was called a noble profession now gets into the category of a commercialized profession, where the patient is a consumer? You put the medical profession under the Consumer Protection Act, just like a product. That means healthcare becomes a product or a commodity. So this is bound to happen. Then there is the mutual trust between patient and doctor is replaced with mutual suspicion. That is expected. I mean, when you say that now you are a consumer and you can, for everything, you can go and complain that I did not get, there was deficiency on service and all that, the trust is going to fail. So this is all part of the various evolution of changes that have occurred in the healthcare scenario.
Thank you, Dr. Kapoor. Rushali, quick question. We need to move on.
Yeah, sure. So I actually have two questions. One is in the real negligence cases which are being handled, what is the success rate that is currently being observed, and does it invariably end up giving monetary compensation, or there are other ways of resolution of the query or of the dispute? And the second question is, in case of, as doctor said, that only non-real cases, real negligence cases are considered for dispute. So what happens where there is non-real cases? Are they not managed by the association at all?
So first question is about compensation. Yes, it involves, in a case of real negligence, it involves payment of money, 5 lakhs, 10 lakhs, whatever it is, figure is mutually decided, that amount is paid to the complainant. So it's not only that. However, you raised a good question. Often the patient doesn't want only money. He's not doing only for money. He also wants you to say sorry. He wants to hear a regret. He wants to understand that this will not occur again. He wants that assurance. Often that is the consideration. Money is of course there, but so this saying that, look here, I suffered or my relative suffered. Now I don't want, you might do it again. Somebody else will suffer. So at least I want to make sure that you don't repeat it and others don't suffer. So often that is the consideration. And as far as the non-real cases are concerned, what you mentioned, which are not real negligence, which are perceived negligence. Now, I didn't, that slide was missing somehow. In perceived negligence, what we do is, that means the relative or the patient feels that there was negligence genuinely, not he feels there was negligence, but being a layman, the person is ill-informed. So there it is patiently explained and patient is counseled. And often a reasonable patient understands that, yes, okay, I thought that this was negligence, but no, this is why it happened. And he's often satisfied with that. So it's not that we say, okay, no, it is perceived negligence and now we are not going to have any further dialogue with you. You try to convince the patient. Also, if need be, the doctor says he's sorry. Now, this in USA is a problem. The doctor finds it difficult to say sorry, because if he says sorry, it could be used against him. He's worried it will be used against him in the court, and that is why, even as far as the money is concerned, whatever monetary compensation is done, often doctors feel that parting with some money or giving some money is admission of guilt. That itself, why did you give money? So there have been some cases where they have used it to say that, look here, doctor has admitted his guilt. Otherwise, why would he pay? So again, these are issues which I think are quite resolvable, but we need to first identify, recognize them, and then find out how to go about it.
Okay. I hope that has answered your query, Vrushali.
Yes, certainly, sir.
And also, I'd like all of you to hold this thought, this differentiation that has been done between the real negligence, a known complication, a perceived complication, and a matter where there is mischief. We will have a session which will involve what can be mediated and what cannot. What has been shared by Dr. Kapoor is what is currently being done. I think all of you, once you go through the process and you understand what mediation is, you may have your own views about when it works and when it doesn't. And that would be an interesting discussion to have at a later point in time, during the course, of course. So that's something I'd like you all to hold for now. And let's proceed with the next step.
He's sharing.
Okay, so let's first understand today. Dr. Kapoor spoke about ADR, alternate dispute resolution. Mediation is a form of ADR. So we're going to go back to very basics. Some of you may be aware of this. Some of you may be practicing ADR professionals. Some of you would have participated in various forms of ADR mechanisms, may be aware of the court litigation processes, and have been involved with the legal processes for a while. But for the advantage of the entire group, let's just understand right from the beginning what is ADR. So first of all, what are the ways we resolve disputes in India? And to understand that, let's just discuss one routine problem that any one of us could face. You are seeking admission for yourself or your child in a college. The 3 lists are out. You have higher percentage, but somebody with a lower percentage is in the list and your name is not there. You desperately want to get into the college. What and how will you go about resolving this? Any thoughts?
Go and meet the concerned authority and talk to them.
Okay. Meet the authority.
File an email or written complaint so that something remains on record. Because what you go and talk to them will not be on record. They may say just sideline.
So create a record. But
Create a
basically, you are saying we'll meet the authority.
I will probably go to the with the required criteria and see if I really fit the bill or if there's something which I have missed and I have not taken into consideration that it was a point to be noted. And if I fulfill the required criteria, and marks is not just the thing. Sometimes you have these minority institutes or some specific people are going to be taken, something of that kind. Like for ESIS medical colleges, only the ESIS beneficiaries are allowed. That kind of a thing.
Okay, so you will.
Once you discuss with the authorities, you will come to know what are the criteria and why this deviation has been done or not done or what it is.
Better to go with the homework, sir.
Yeah, yes.
Okay, so let's not there's no right and wrong. It's how you will approach it. So let's go with that. First we've said that women will meet the authorities, will create a record that there's something not okay about this selection process, or rather the selection, and you want an explanation as to why this has happened. Is there an error? You will also do your own research in terms of what is the criteria for the selection. Anyone else? Any other methods? Anything else you can think of? Mrinalini, you want to say something?
Yeah, I'm not sure how much this would help, but perhaps talking to the person who got in, like just having an idea of the person who have people who rather have gotten in. So maybe understanding what you lack in your in your CV and what they have better in their CV. So I would probably look at what my other colleagues have put down on their achievements and what I lack before I go and talk to the authorities so that I have like a better negotiating stance per se.
Very interesting. So you apart from the authorities, you also want to have a discussion with the other person who has actually been selected and who you feel is you deserve the selection more than that person. Okay, that's interesting. Any more thoughts? Yes, Vishwanath? You're on mute. I can't hear you.
I would also check the prospectus and see the eligibility criteria and the grounds.
Okay, so basically exactly what Deepa said. Okay, anyone else?
What I feel is that better to take past history of the institution on what criteria they do give the admissions, whether it is money factor or whether it is merit factor or whether it is reservation factor.
I see. Okay. So you also want to look at that angle, whether, there's a donation involved and other criteria such as reservations involved. Okay.
There are some trustee seats also reserved. So
Yes.
that also somebody might have taken by paying or by.
Correct.
I would also check which authority governs this particular college admission. So whether it's University of Mumbai, whether it's
governing council, whatever is the governing council, because eventually we'll have to take that issue to that governing council if the local college authorities cannot give you a proper relief to your grievance.
Right, right. And if I see all of you have spoken about it, most of you have spoken about ways in which you will explore the problem. You will look at what exactly happened. You are not assuming that the institute is wrong. You are trying to find out whether there is something that you don't know. Okay. In fact, none of you have mentioned that I will hire a lawyer and send a notice. Or go directly to the court. All of you have, looked at ways to kind of talk about it, find out more about it. And that's the natural inclination of people.
Madam, we are not lawyers, no? We can't think of that way.
Yes. And actually, that is not just not just that you're not
Even lawyers may not get justice in a short period.
So it's not just lawyers. Anyone you speak to will have a lot of resistance to go to court directly, to look at that route, because that route does look intimidating, and people want to find solutions. People want to explore solutions that work for them without going to court.
Actually, on a lighter note, there is a saying in Marathi which says that कोर्टाची पायरी शाणे माणसाने चढू नये.
Exactly. In fact, even in our last training, somebody had mentioned the same, what do you say, saying. The exact saying was said, and I think that is that's the attitude that we all hold. In more so in India than in in the US and all that. It's more common because their systems are different. But in India, we do hold that let's try and resolve it without going to court. Let's try and resolve it.
They also said कि सफेद कोट और काले कोट से दूर रहिए. The other way of saying the same thing, doctors and
yes.
Coincidentally, we are discussing the both together here today.
Yes,
the last session was,
we are all together here.
The last session was purely on medical and legal, both.
Yes, yes, absolutely.
But I would like to add that you should go at a right time. You must get to both, of course, to doctors also, more particularly to doctors. If you go at the right time, it can save the life of the patient. But generally, it happens that when the problem is become a critical one, then we go to the doctors. The same is the case with advocates also.
And therefore, we can kind of conclude that we are all naturally a population that is inclined towards looking at better options, other options, alternate options to litigation. I never would like to say that one option is better than the other. Litigation is an option. At some times you need to look at that option. And so is every option available to you for relief. But at the same time, litigation as a first option is not something that people want to do. However, the way we are, our legal system is structured or was structured, we still don't have as many ADR avenues available to us before we go to court. Just as Dr. Kapoor said, there are a lot of issues that have been there, and slowly those issues are getting resolved, and ADR is becoming more and more accessible to people. Now, as a nation or as a culture, we have always had a system that was designed. In fact, this appears in Chanakya's Arthashastra, that how to manage conflict. was given upaya is what he calls it in the Arthashastra. He gave 4 upayas that need to be looked into or implemented prior to getting into war. And those upayas are Sam, Dam, Danda, Ved. We've all heard of them. It basically means that you first reason out, talk to your opponent, understand your opponent's, what is it that the opponent wants, and use patience and understanding to resolve the issue. If it doesn't get resolved, you look at Dam. So like in the earlier example, you could look at, is there a donation to be paid? Is there something where I can pay and get the seat? That is Dam. That is a way to buy something out by paying a price for it. In the olden days, there was the culture of marrying between kingdoms, giving your daughter as a gift and creating a relationship so that you would maintain peace and harmony between 2 kingdoms. If that did not work, or if the gift that you were offering was not something that the other person was inclined towards or accepting, you could go to the next stage, which was Danda, which meant that using some kind of force or some kind of method by which you would cause or show the other party that you have strength and you can cause them harm. This included economic sanctions. This included some form of, closing roads or access or water bodies, all kinds of methods which were negative in nature and which would kind of give the other side a message that if we don't resolve our dispute, you will have problems. There will be implications or some damage would be caused to you. And finally, it was Bhed. And Bhed was basically war. It could be political war. It could be, it could be diplomatic war in terms of even divide and rule policy, which is spoken about in Arthashastra, where you basically create an environment of hostility within the kingdom. It could be that, or it could be actual war. So that came under Bhed. But there were specific steps that were provided, and a lot of respect has been given to this Arthashastra at that point in time. And it appears that that is how governance was, in over the ages. And I think as a culture, that's the culture that we followed in the way we interact, in the way our conflict is resolved. Does our legal system provide for that? Yes. And that's what I'm going to explain to you now, or rather we are going to explore. It's not something that we think about when we think about, what are the options when we go, when we have a dispute, do we go to court? But yes, there are a lot of mechanisms we can use before actually filing a case, sending a notice, or using a method that is equivalent to war. So this is a quick understanding of what Sam, Dam, Danda, Bhed means. I've just explained it to you. And therefore mediation has a long history. Mediation comes under the category of Sam. Even traditionally, mediation is considered the best style of dispute resolution. And, or rather the, again, best style is what we like to call it, but you can say the first option, or something that you should try before looking at other options, because the other options could be far more destructive to the issue and to the people involved. So there are certain criteria that you need to understand to say that would going for litigation or going for any other method of dispute resolution, help in this case or not. And that's a call you should be able to take once you complete this course, in terms of all the methods that are available to you, and whether at this point of time should we attempt mediation or should we attempt something else. So that is that's what we need to see, and that is why we are focusing today on mediation, to try and understand what it is and see if that's a method that can be used in our conflicts, be it in our professional life, be it in our personal life, be it in our communities. What are the traditional matters that I'm referring to here? The police, courts, criminal courts, civil courts, and constitutional remedies that are available to us. What are the other methods that we talk about when I'm saying alternate dispute resolutions, or ADR? These are a few options that we have that we can use apart from going to court. This includes conciliation, arbitration, mediation, judicial settlements, and Lok Adalat. Now, Lok Adalat and judicial settlements are part of the court systems, but they are not the same as getting a judgment. A judicial settlement is when a judge who is hearing your case understands or realizes that there is an element of settlement that's available, and the judge himself proposes a settlement, and if the parties agree, you get something called a judicial settlement. And Lok Adalat is where cases are referred by the court to a system called Lok Adalat, and it's a fast-track method of resolving a dispute. It's mostly in the form of a settlement and not really in the form of a judgment. So those are the two methods, which are alternate dispute resolution methods within the court system. Conciliation and mediation, right now, these words are used in different statutes, but they kind of mean the same thing. They mean where a neutral person tries to find a solution through negotiation between two parties or two or more parties. Okay. And arbitration is a method which is actually similar to the court system, but it's a private method where a person who is appointed by the parties listens to both the parties, appreciates the evidence, and passes what we call as an award, which is similar to the judgment that is passed in court. So those are your ADR mechanisms. So when we say ADR, we mean these mechanisms. Also, negotiation is one ADR where there is no third person involved, but it's between the parties themselves. Dispute resolution stages and steps. So if you look at how disputes escalate, it's always better to prevent disputes. When we look at medical disputes, we can talk about how consent is being taken, how risks are explained to the patient, documentation is maintained. Almost all hospitals and all doctors follow a process-centric approach, wherein you have certain processes that are designed so that there is no negligence or there is no mistake that is done. So that is prevention. This kind of prevention exists in all kinds of professions. Even in personal life, we try to see that we don't get into a conflict. First of all, if we see that there is a problem, we try to address it before, or we try to see that the problem itself doesn't arise. So that is through documentation, agreements, understanding, sticking to the understanding that we've had. That's prevention. Now, if problem arises, like some of you mentioned right in the beginning, when we looked at that scenario, we discuss it with the other person with whom we are having a problem. So that's another, another stage or step, which is called negotiation. This is between two parties. There's no third party involved. Then we have something called non-adversarial ADR, which is mediation and conciliation. There's adversarial ADR, which is arbitration. And then there's litigation, which is civil, criminal, constitutional. Okay, so these are your methods of various methods. And the way they are arranged is escalating hostility, cost, and time to achieve resolution. If you prevent it, or the issue itself will not arise, or if it arises also, it will be resolved immediately. If you take care of preventive mechanisms. Where there's negotiation and talking to the person directly, it's informal, it's quick, you can resolve your conflict and move on. When you go for a mediation, it's slightly longer than negotiation, but it's again informal, relatively informal, and it can be quicker. Arbitration is slightly more formal. It's adversarial in the sense, and I'll explain what adversarial means over here. It's between two parties. You have lawyers representing, you have a neutral who passes an award, who appreciates the evidence. So it takes a little more time and it is more expensive. And of course, the nature of the process is such that the hostility between the parties grows. And then there's litigation. And as we all know, it has the maximum amount of hostility, cost, and time to achieve resolution. And there's another major factor here. When it is in that same order, when you choose to mediation or negotiation or mediation, parties have more control over the process and the outcome, because you yourself are deciding what is happening. When it is arbitration or litigation, then the parties give up control because it's somebody else deciding for you. You only put out that this is what has happened. These are my rights. These are the violations. This is my evidence. Whether the judge finds that right, wrong, and what the arbitrator feels about it is completely the call of the arbitrator. And therefore, the control is with the arbitrator. It's different when you yourself are negotiating something. You may accept or you may not. And I'll explain. It's a similar kind of position that the party has in mediation. What is the meaning of, okay, so let me just stop here and ask if anybody has any questions so far about the processes. It's important we understand this. So any questions so far?
If mediation fails, then what it goes to the arbitration or it goes to the court directly?
Depends on what has been agreed in your agreement. If you have agreed that arbitration is you agree to arbitration, then you mediate and go to arbitration. If you agreed that certain court will have jurisdiction, it goes to the court. So it's agreed between the parties. So generally, if it is if there is a formal agreement between the parties, it will be what the agreement says. If there is no agreement, then it will go to court. Okay.
Okay.
So we have two broad categories of mechanisms, dispute resolution mechanisms. One is adversarial and the other is non-adversarial. What we mean by adversarial is a third party, either a judge or an arbitrator, decides the outcome of the case. is the one who passes the order, passes the judgment, passes the award. So he understands the matter and he is the one who decides. Formal proceedings are held in public following strict procedural pattern. Okay. In arbitration, the procedure is not as public as in litigation, but it is still, it is still in front of everybody, and everything is put out in the open. So there is no confidentiality between the parties. And sometimes that's very important to parties. And you'll know what I'm talking about once we understand the process, but basically it's a very public kind of process.
But in arbitration also, third parties are not allowed to inspect, no? Or what? In court, I can go and sit and watch any proceedings, but in arbitration of say two companies, I am not allowed. That is in a closed door. Only the person concerned are about that.
Yes, but there are times when there is information which you want to keep confidential from the other party also. That option is not available to you in arbitration. If you want to bring it on record to the arbitrator, you have to disclose it to the other party. You have to give the other party the chance to be able to reply to it. Even though that factor is very important for a certain decision, but it could be confidential. It could be a trade secret. It could be a financial issue which you don't want to disclose to the other party. So that's why it is a method that is private between the parties, but not private for a particular party. So it's from that perspective, you have to share all your information before the arbitrator, that which you want to bring on record. The decision award is binding on the parties, subject to challenge on specific grounds. So if a decision is made by the judge or arbitrator, it's binding. You don't have a choice. Once you've submitted yourself to the process, you have to accept it. Payment of court fees or arbitrator's fees are key elements to the decision. Let's look at the differences. Adversarial methods are formal, non-adversarial methods are informal. Adjudicative and non-adjudicative, that means adversarial methods, there is somebody who is judging, who is deciding. In non-adversarial, it is basically the parties who are deciding themselves. There is a process that is defined in adversarial. Non-adversarial is a far more flexible process. Adversarial is evaluative in nature. Non-adversarial is non-evaluative in nature. What do we mean by that? Adversarial methods rely on facts, on evidence. There is little to no importance given to circumstance, to basically feelings, emotions, and that kind of, that kind of elements which also influence decisions and which also influence things. But those matters are not considered. They are strictly on the basis of evaluation of facts and evidence and in relation to the law. Whereas non-adversarial methods are non-evaluative methods. They are slightly more broader. They take up a more broader perspective of the matter. Third party controls the process and the outcome. In non-adversarial, parties control the outcome. And sometimes also the process, particularly in cases like negotiation. Adversarial looks at the past. Non-adversarial looks at the future. So that's a very important point, that in adversarial mechanisms, it will always be about whose fault was it and why and what can be done about that fault. It's the past. Non-adversarial, it's more about how can we solve this problem, both of us together. How can we solve this problem now that this problem has come up? Focuses on facts and focuses on relationships. Adversarial methods seek to establish liability of faults. Non-adversarial methods seek to reconstruct or maintain relationships. There's a winner and loser in adversarial. You have to get a judgment. There's no something like, both of you are right. One has to be right and one has to be wrong for that matter to have finality. That's the nature of the beast. And because of which there has to be a winner and loser. There is nothing in between. Whereas non-adversarial methods are accommodative. You can find ways in which both parties can win a little and lose a little. Adversarial, as Dr. Kapoor has also explained in this session, results in a general rule. It gives you a precedent. Whereas non-adversarial methods are custom-made solutions and are never considered precedent. So just because you've had an agreement with one person, just because somebody else has the same or similar case does not mean you have to have the same agreement. In all probability, the agreement with this person will be kept completely confidential and will not be used as a precedent for another case. So that's a very big factor, I think, for cases such as cases where there's a liability. Adversarial methods are dominated by lawyers, whereas non-adversarial methods are controlled and centered around parties. So parties play a major role. If we look at arbitration versus mediation, arbitration is adversarial, so it will make it easier for you to understand what we are talking about when we're talking about adversarial and non-adversarial. Arbitration is adversarial in nature, whereas mediation is non-adversarial. Arbitrator decides the outcome. Here in mediation, parties decide the outcome. Arbitration is private and confidential. Mediation is also private and confidential, but remember the difference that I explained to you. In arbitration, if you want to bring a fact on record, you have to bring the party on record. You have to share it with the other party also. There's no such thing as only giving it to the arbitrator. Whereas in mediation, there are provisions where you can explain things to the mediator, and it's the mediator's job to look at whether that is something that is relevant to the case, how it can be used to find a solution, because mediator is really not judging. So there's no consideration of evidence or anything like that. It's just about whether that factor is relevant to finding a solution, and if it can be used in a way without disclosing that fact to the other party. Arbitration is formal, mediation is informal. It's a flexible process and legally binding process and award. Mediation is legally binding once the agreement is signed. Before that, you can move out of the mediation process at any point. Just because you attempt, like for example, you agree to an arbitration. When the arbitration award is passed, whether you like it or you don't like it, it's binding on you. Whereas if you agree to mediation and you come to a point where a certain solution is given, or you come to a certain solution, but you don't feel completely comfortable with it, it's not binding on you till you sign the document. So you can always exit and go to court or look at another mechanism rather than accept something that you don't feel is fair or is acceptable to you. And then we have something called institutional area, something that CMC is providing. This is a place where an institute empanels neutrals. They have their own rules relating to how the process has to be, done. This is, they conduct arbitrations and mediations and conciliations. Now there is no concept of conciliation because we have a Mediation Act. But when we had the Arbitration and Conciliation Act, there was conciliation, and all of that was conducted in a professional manner through a structured procedure that was defined by CMC. The documentation and administrative support was provided by CMC. Neutrality was maintained because it's a neutral third-party institute which empanels several professionals, and you can choose the professional, or they will allot the professional if you so tell them to. And that professional will not be related to you in any which way, because we have a process by which we, as mediators, as arbitrators, all of us have a process where which if you approach me that, there's this case, I'll first ask you who you are, who is your opponent, what is the case about, just a brief understanding to tell you whether I have any interest in the subject matter or in any which way I am, if the parties are known to me. That's called conflict of interest. And wherever there is a conflict of interest, I don't have neutrality, so I cannot be an arbitrator or a mediator in that case. And CMC will, or the institute will take care of that neutrality for the professional as well as the parties. And they have a panel of trained professional neutrals to choose from. The idea of this training is to have, and we are having professional trainings also for the professions, is to have trained professional neutrals to be available so that the industry can come to the institute for resolving their disputes. Because one must understand that if I have a problem, like I have a problem with a company, and the company says that one of our employees will be a mediator, you're not going to like it. You're going to say, oh, he's going to be on the side of the company because he's being paid by them. Whereas if you go to an institute, that person has nothing to do with your company, so he becomes a third party, and you have more, I have more comfort knowing that this person is not related to the company with whom I'm having a dispute, and I feel comfort and the fact that, okay, this is fine because this person is unrelated. He has no interest in the subject matter. He has no interest in both of them. He's a professional. He'll be able to help us. So that is what neutrality does. And that is why institutional ADR today is gaining a lot of recognition. And that's the way forward. Of course, you can be an independent neutral and offer your services. But when you come through an ADR institute, it brings that much more weightage to, it's more acceptable for people who are in conflict, simply because you are unrelated and you're not coming from any one party's side. So I want to know if there are any questions on this, on what we've covered so far. Also, I have a request from the next, I'm having one more small session to complete. If you could keep your cameras on, I can, I can understand whether we are, if you're understanding what I'm saying, if, if I'm just talking to, without you all understanding anything, or it's nice to get that cue from you all. So it would be nice if we have the cameras on. Also, as mediators, body language is a very big factor, and you all will know that as we proceed with the course. And just understanding how, the room is, what your colleagues are doing, how your, how the messages are being perceived is a good place to start, because online dispute resolution is also a very big thing right now. Many of us are doing a lot of cases online, and we are seeing people only through through the screen. And it's a good place. This is a good place to start and understand how we can conduct mediations online also. So any questions?
Kandaji, I have got one query related to institutional. Am I audible?
Yes, 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 Ranjanji.
If there is an arbitration clause in an agreement, and it doesn't speak anything about the institutional mediation at all. It may be a sole arbitrator, or it may be each party to appoint an arbitrator. Now, in that particular given situation, if one of the party desires that instead of having any individual appointed as an arbitrator or any group known person is to be appointed, let us try to go to an institutional arbitrator. But then there are two parties, two separate parties. One is sending the notice to go ahead with the arbitration, and that party wants to specify that, okay, there are two options. One is X institution, another is Y institution. So if we will go by the rules of that institution, and we will request that particular institution to appoint arbitrator on each side. So whether it is appropriate, because the agreement is silent on that particular aspect. That is one. So that is one. Let me have another also.
Complete your question.
Suppose a fresh agreement is to be drawn, and a reference to the arbitration institution is to be made. So how that should be properly worded? Each party would have an access to, or it will be designated that X party will approach to a particular institution, and Y party will go to some other institution, whether by name or otherwise. I mean, just like to.
Okay. So first thing is both arbitration and mediation. It's critical that the parties both agree that they want to go for institutional arbitration or institutional mediation. Okay. What can be done if an agreement does not have that included? You can write to them, or you can discuss with the lawyers, or if communication is still ongoing between the parties, you can discuss and say, okay, let us go for institutional because it's quicker, it's just more professional. Let's do that instead of appointing an ad hoc arbitrator. So that's one part that can be done. If you come to an agreement, you can't have two separate institutes, because the rules of each institute is different. The professionals may not be registered on both, so it becomes very complicated. So let's not complicate the process. There's already a conflict which is complicated. Let's not complicate the process. It can go to institutional arbitration only if both parties agree to the same institute.
Okay.
Then every institute has their recommended clauses. It's already there. So if moment you go onto their website, they will have their clauses. You can take that clause, change it the way you want, and put it in your agreement. So that becomes your arbitration agreement or your mediation agreement.
Do I take it that, I'm sorry, do I take it that what we have to do in our arbitration agreement is that X or Y, these are the institutions, they may help us to appoint, and we will have to follow either of the two, or we can say that, okay, only X is the institution to whom we should approach, and it will assist us in having two separate, because I'm assuming a situation where each party is entitled to have an arbitrator. Now, in that given situation, same institution can appoint, we have to ask the same institution to appoint two separate arbitrators, and then there will be a principal arbitrator.
Absolutely. But you cannot have two institutions. You should have one institution because the rules of every institution is different. Have we lost?
No, I'm
Okay, you are
still.
there? Okay. So basically only one institution, two arbitrators. Each party can choose their arbitrator.
Okay.
Okay.
Thank you.
Can I ask a question?
Yes.
You just mentioned about online mediation and arbitration, right?
Yes.
So how do you record? Because generally when we have a physical mode of arbitration, we take the signature of the parties. Similarly, at the end of arbitration or mediation, at the end of the mediation, you have a mediation agreement where the parties sign. So how do you go about that?
Okay. So every institute has their own mechanism. There are some platforms that are used, and the platform has an OTP system where your numbers are registered and you get a message, and then you have to sign through the OTP. So there are some digital methods that are used for ADR systems. Sometimes digital signatures are used. So every institute has different mechanisms to ensure that all this is done. It's a very beautifully designed system. So you know, if you join one of the ADR platforms, you will realize that there's a lot of work that's gone into design and use that system.
Is there a process to identify the parties, because there can be
Yes.
impersonation?
Yes. Yes. Of course, you are expected to submit your documents at the time of right in the beginning before your case comes up, along with letters of authority and wakalatnamas and all of that is there. And also, we never do online session with the videos off. That's not allowed. Like, not even one party is allowed, or a lawyer is allowed to keep their videos off. That's mandatory. So, and recording is switched off. So those are the things that we ensure, but otherwise a certain amount of trust is also involved.
Because when you are giving evidence, you are saying something on oath.
Yes.
And that is also administered online.
Yes, that is also administered online, in the digital way. It's a way where you use some physical methods, and I mean some physical, like digital signatures, or you can sign something and send it by a scanned copy, sometimes couriers, or you have an OTP system. Like some systems are designed where you register a number, you get an OTP. So if you want to say okay, then you put in that OTP, and that's how it works, just like our banking system.
I have a question. Can you hear me, Ganda?
Yes, Dr. Kapoor.
Now this, after the mediation is over, an agreement is signed. So this is on stamp paper. What kind of paper is it, the agreement that made?
If it needs to be on a stamp paper, it is. For example, if there is an indemnity and all of that. But if it needs to be, it depends on the stamp act. You know, what is the kind of agreement that you get into.
My reaction to the query is this, that minimum stamp paper is required to be used, because if you want to have a proper agreement, which would, if at all it is challenged in any court of law, then it has to be properly drawn. So in the concept of properly drawn, some minimum court fee, stamp duty would be required to be paid. In order to make any document legally binding, there are two things. One is agreement and another is called contract. So you have to differentiate between the two. Suppose I make you an offer to start smuggling and you agree, there is an agreement.
So
But
I would just stop Rajanji there, because it also depends if you're going under the Mediation Act. Then it's different. If it's a court annexed mediation, it's different. So maybe we can address that when we take up the legal case. So it's not a blanket thing. What Mr. Ranjanji is saying is absolutely right. If you are like just having an agreement to negotiate, like to mediate, and it's not under any act and all that, and you go ahead and it's like a contract, then you need to have a stamp paper, at least a minimum stamp paper, and then calculated depending on what is the transaction. But at the same time, if it is coming under the Mediation Act, or it's coming, then we have to go under that. And I will get back to you with respect to what that is going to be, because we are still, the act itself is new and we are still understanding all those.
I have got slight different opinion
Yes.
for the simple reason, because in recent times there are a lot of cases that are being reported with reference to if the arbitration agreement is not stamped, what is the effect of it? Similarly, because I think stamp duty is a altogether state subject.
Correct.
Whereas the mediation or mediation is concerned, that is not a state subject now, because the central government, the parliament has enacted that law. So depending upon the place where you are going to have this particular, you will have to first check with the legal requirement as far as stamp duty is concerned.
Exactly. So I think that's a question that we can look at that, when we look at the legalities.
Can I ask one thing?
Yeah, Gandha, I just wanted to ask, can I ask?
Yes, please.
Yeah, this number of arbitrators and mediators per case, like, I mean, does each party have its own arbitrator and mediator representing them?
That
Or it's a
depends on
common arbitrator and
So mediator is generally one, unless you are having something called co-mediation. I'll explain that at a later
Okay.
point.
Yeah.
Arbitrators, so you can have you generally have it that you have one arbitrator per party, if that's in your agreement. So whatever is in your agreement, what they are talking about is where you have an agreement which says that we will appoint an arbitrator each. So that's the way that the agreement is framed. So everything, as far as ADR is concerned, you have something called an ADR agreement. So you either choose rules of a particular institute and go by that. So that institute would have rules relating to how an arbitrator is to be appointed, how many arbitrators, and all of that. And you choose whether you want a sole arbitrator, you want two arbitrators, or you want a bench where you have, both the arbitrators choose a third arbitrator. So that's the way you'd agree in your arbitration agreement what you want. As far as mediation is concerned, there's always one mediator, but we do have a concept of co-mediation where we have more than one mediator, and their roles are divided among themselves. So that's the way mediation works.
And with multiple arbitrators, who takes the final decision?
So there's a definition of all. I mean, all of that is given in the rules.
Okay. Fine. Thank you.
Ma'am, can I ask one thing?
Yes.
Yeah, actually, I can understand the role of mediation in healthcare and dealing with patients and problems in it. But is there a role for arbitration? I mean, are you actually looking at arbitration as a role in healthcare? Because having a third party in this who actually decides the amount, but I'm not really very sure whether that is.
Okay, so before we proceed, one of the things, Dr. Preeti, is that we when we look at conflict, we are not looking at only doctor-patient conflict. When you look at healthcare, there are various types of conflicts. You will have conflicts within the organization. You will have suppliers. You will have transactions. You might have land deals where the hospital is situated, lease agreements. You have various interactions which happen, which also, I mean, if you look at just workplace disputes within the healthcare industry, that also is a kind of dispute, right? So I have seen agreements where hospitals have asked their consultants to have, that if anything happens between them, the matter will go to a sole arbitrator, and the sole arbitrator will be so and so person. So as far as that industry is concerned, there are a lot of agreements that exist and lot of types of disputes. And even within your when you signed your consent and all that, if you put a clause there that any matters that arise out of this will go to arbitration, then the matter goes to arbitration, because the courts are just waiting that if they can proceed, they can give matters to arbitration, except where, of course, you are choosing to go for consumer disputes, where those are beneficial legislations. So those may, those you have certain rights when it comes to consumers. But otherwise, if you agree to an arbitration clause, you will go to arbitration. Does that answer your question?
Yes, ma'am. Yes.
Madam, can I ask a question? Can I ask a question?
Yes.
Yeah. See, basically, if my consent has a arbitration clause in it, if I have a clause, how binding is it on the patient? Because it is not a contract which is actually registered. It is not one of those things where when a patient is saying, I agree to undergo this procedure.
I'll tell you what is the general attitude of the judges. Okay. When there is an ADR clause in your agreement, be it arbitration, be it mediation, the judge will actually, the matter, if you go to court, what you're saying is when there's an arbitration clause, how binding it is, meaning that you want to go to court and not go for.
No, I don't want to go to the court. The patient goes to the court, and how about
patient?
Because I will get the end of that consent, right?
Correct. So the patient may want to go to court. So when the patient goes to court, the judge will generally say, see, your case, your contract has an arbitration or a mediation clause.
So a general consent that we take stands like a contract.
It is, I mean, basically, again, over there, the judge may give an option to the patient. Do you want to go ahead with the arbitration? So in a case where there's a patient or a doctor dispute, and particularly if the patient goes to consumer court, they may not force the patient to go for arbitration. But where there is an arbitration clause and he goes to court and not to the consumer court, in that case, he will be told to go for arbitration.
Even for the criminal case, if that is filed? If a
criminal is not applicable in arbitration.
Okay.
Arbitration is only civil cases. Yeah.
Okay. Thank you.
Just to contribute to what has been discussed right now. See, if you want to invoke some expert, you will have to specify in your agreements or in the consent which you are obtaining. Your consents are basically agreements. There is no dispute about it. There cannot be any dispute about it. But question is that what is the nature of that consent? Because if it is a blanket consent obtained, for example, in the building industry, or what is happening is that the builders are taking blanket consents from the flat purchasers. Then issue arises whether that is still binding or not, and the courts have very heavily struck down these blanket consents. So you will have to, when you are taking consents, what type of consent you are taking, that is really material, because we are discussing about health industry. This is what is my view. And secondly, if you desire to engage or take the benefit of some experts, then it would be better that in case of dispute, you would like to have mediation or arbitration, and that would be the person who is engaged as a mediator or arbitrator, he will have a liberty to take the expert opinions. Then only the arbitrator or the mediator would be in a position to take the advantage of the knowledge or expertise of any expert. This is what I would like to submit.
Thank you, Ranjanji. I would like to basically just proceed with the next one. Just give you a little bit of idea of what we are going to discuss tomorrow. So now that we are discussing conflict resolution and dispute resolution, can you tell me what is your idea of a dispute? What do you think is a dispute?
Difference of opinion or difference of understanding.
Okay.
Disagreement.
The fourth option is correct. Anything that brings discomfort in the relationship between two or more people.
Okay.
I think all of them are in some way correct.
Okay. So it could be a disagreement, could be an argument, it could be contrasting claims of rights, anything that brings, anything that's uncomfortable in a relationship between two or more people is a dispute. There's a beautiful definition of the term conflict: an expressed struggle between at least two independent parties who perceive incompatible goals, scarce resources, and interference from the other party in achieving their goals. Now, remember that the first one that we talked about was dispute. And now we're seeing the word conflict. They're not the same word. We do use the word dispute resolution, conflict resolution, but is it the same thing?
No, basically, there is a difference. Basically,
There's a difference.
there is a difference.
There's a difference, and this definition kind of tells us exactly what conflict is. It's an expressed struggle, so it is to be expressed. Just because you have a disagreement, you have discomfort, does not mean that it's a conflict. Till it is expressed. Also, there has to be interdependence between the parties, some form of relationship. You do not have a conflict with somebody who you do not have any relationship with. It's ongoing. And for that ongoing, there's a relationship between people who perceive incompatible goals, scarce resources, and interference from the other party in achieving their goals. So there is something that's stopping you, that's causing an obstruction on your path. So that is what conflict is. Okay. So understanding that aspect of conflict, is conflict good or bad?
Sometimes it may produce a good result also.
Okay.
Difference of understanding is always professional understanding. It is not conflict, but difference of professional understanding is good also. No? It might be on a right way of, I may be doing it by X way, somebody might be doing it by Y way. But when we discuss not as a conflict but as a professional, we come to a better solution. It might not be a conflict, but it might be a difference of understanding.
Okay.
Conflict is bad unless it's resolved.
Okay.
Conflict
Samudra
can-
Manthan.
Sorry.
Sorry.
Manthan. Okay. Who's
Sam-
that?
Samudra Manthan. You will get poison as well as Amrut.
It depends on the Manthan. Manthan is a process, right?
Yes.
Okay. Mrinalini?
Yeah, I think it can be perceived as good or bad, like Rajan sir said, because if a conflict is resolved, I think rather than staying in discomfort and like not exhibiting expressly that there is a conflict between two parties, it's always better to resolve it so that in the long term you can work together so that the relationship still stays, rather than not having a conflict and staying mute about it till it becomes a full-fledged fight. So I think in that terms, expressing a conflict is rather better, and resolving it earlier is better.
Yes. Yes. Okay. Rushali?
Conflict can be good or bad depending on the outcome of it. If it's something which is giving rise to innovative ideas or different horizons, opening different avenues, it can be good. If it's something which leads to disputes, it is bad.
Okay. One thing is for sure, whether it is good or it is bad, it could be either, as you all are saying, depending on what the outcome is, it's inevitable.
It again depends on how do you look at it. Am I audible?
Yes, it's how you look at it, but it's also that, you may do a lot of things to prevent conflict, but you cannot guarantee that it will not arise. It is inevitable. It arises when there is interaction between people, conflict will arise. It's our perception of it, or rather our inherent beliefs of what conflict is, that affects the way we deal with it. And primarily, we can hold a belief that either we can say that conflict is natural, it's inevitable, or we can look at it that conflict is bad. Now, if you have an inherent belief that conflict is bad, and when conflict arises, we do have ways where we either become aggressive, because in our mind, what is influencing our behavior or our reaction is the fact that we will not, now this is going to cause something bad. This is a bad thing that has happened. So we either go into avoidance mode, we become aggressive, or we use, we act as if it doesn't exist. We kind of go silent on that issue. Any of these methods, when used, it's going to escalate the matter. You can take up any conflict that is there in front of you, at least most conflicts. And if you let, if it arises, if there's something that arises and you see that there is a disagreement, there is a discomfort in a relationship, and you don't do anything about it, you just avoid it, it is going to escalate. Whereas if you have an approach where you say conflict is natural, when conflict occurs, you will choose to talk about the problem. And if you talk about the problem, and if you approach the problem with an attitude that this is natural, this is, disagreement is good, let us talk about it, let's find a solution. In all probability, you will face growth, harmony, because whatever is that obstruction or that problem that's coming because of the misunderstanding or the disagreement will actually help. When you talk about it, you'll find ways to grow. It'll be you'll find newer things to do. You'll find ways to approach it in a different way and grow. And therefore, as people who want to, who deal with conflicts all the time, either as, as professionals, as people who are having relationships, we will get into conflicts every now and then. It is our attitude as to whether we expect it. It is our attitude, whether what we think about it, that will determine how we will approach it, and then eventually what results we will get. Any thoughts on that? We are coming to the end of today's session.
It depends whether you are at peace with your own. If you are at
own.
with your own, if you are comfortable with your own, if you are cool and ready to accept the point of view of the other, then naturally there will be less friction. All as far as moving parts are concerned, especially in car and all, they put oil.
Yes.
So that there is a less friction. And I think having a peace with oneself is the best sort of oil for avoiding frictions, conflicts.
Very nice, very nice way of looking at it. And yes, as we mature and we start dealing with all these issues, I think all of us have our way of handling what's going on in our internal dialogue and our own internal conflicts. And of course, that reflects in our relationship and how we deal with situations. But try and understand be more observant about what is our reaction or our belief system when we are faced with conflict. I invite you to observe that. I've also shared a conflict style survey. It's a small document that has some questions which you can answer, and you can understand what is the style of, what kind of an approach do you generally have. Now, remember that there's no, it's not that you have one style all the time. It's a style that you take up in different situations. But you have one style that dominates the way you manage conflict. I want you all to look at that survey. There is no good style and bad style, but it's good to understand yourself. And tomorrow we'll go a little deeper in conflict management, how people resolve conflicts. And it's really important to understand that before we go into the process of mediation. And that's it from us for today.
Thank you.
Where have you sent that survey? Where will you be sending?
It's in the chat and it will be put in the WhatsApp group also.
Okay.
Thank you so much.
Thank you.
Thank you.
Thank you.